Thanks everyone for joining us today for a quick presentation on vaccine injuries and what can be done regarding the vaccines, that are just coming out now. We have a few LawBank members that will be here presenting, and I will turn it over to them to introduce themselves in turn and to get started. Just so you all know, we will be applying for general CLE credit for this presentation, and feel free to email me directly. I'll put my information in the chat if you have any questions on how to get your credits. And with that, Greg, I'll turn it over to you.
Thank you, Miranda. Welcome everybody to this presentation on vaccination injuries. We're calling it Sticking Points, a survey of remedies for Colorado vaccination injuries. We have three great speakers and myself. I'll be your moderator. My name is Greg Cairns. I have 38 years experience in workers' compensation. I've been involved as co-counsel in 5 vaccination injury cases, and I have a passion for this particular topic, as do the presenters here today. We have four of us total, 3 others. I'll introduce them, tell about them when they come up, because I want to launch right into a couple announcements. One is that the 4 of us today, the 4 presenters, have co-authored a feature article for the Colorado Lawyer, which will be in 2 parts, and we expect it will be published, we believe, in maybe October and November, perhaps November and December of this year. So stay tuned for an exhausting treatment of vaccination remedies in the state of Colorado. In addition, on August 24th, put it on your calendars, there's going to be a continuing legal education starring none other than the 4 of us, the 4 horsemen of the apocalypse, but also some astute, very well experienced players on the national scene who know vaccination law, including a former special master. You're going to want to attend that full day CLE if you really want to get into the details of vaccination injury remedies in the state of Colorado. Today is a taste of what that article in 2 parts and the CLE is going to tell you in more detail. I first want to give an overview and tell you a couple things. One, there's a great resource for studying vaccination injury law. It is authored by a man by the name of Abramson. And I had that book here just a moment ago. I don't see it. If I find it, I'll show it to you later on. It has all the nuances of vaccination injury law, and it's been amended to include COVID vaccination injury law as well. I recommend that to you. There are a number of seminars out there, but none that we're aware of that focus on Colorado remedies. I also want to tell you there's some materials that are available to you that include some flow charts and 9 case examples, which are for illustration purposes, not meant to be obviously counseling you in the law necessarily, because every fact pattern is different, but we might refer to some of them, or you can take a look at them as a test of your abilities of what you learned here today. I'm going to start with a brief overview of the landscape of Colorado remedies, and then we're going to drill down on more specifics later on. Basically, today you're going to hear about 2 federal programs which are designed to compensate victims of vaccination injuries. Mark Saliman is going to tell us about those remedies, but let me tell you this. One of them is a pretty good fund. It's been around for over 35 years. It pertains to childhood vaccinations and certain adult vaccinations, not all. The program is fairly transparent, has reasonable remedies and attorney's fees, even for unsuccessful cases brought in good faith. This is called the Vaccination Injury Compensation Program, or VICP. The other program, its twin brother or sister, is supposed to take care of currently those who are victims of COVID vaccinations or countermeasures. That program, in our view, is not as transparent. It's not easy to tap into. It has limited remedies, has no attorney fees provisions embedded in it, is pretty exclusive as a remedy. Mark's going to talk in more detail about that. That twin brother or sister is called the Countermeasures Injury Compensation Program, or the CICP. Now, these programs have different statutes of limitations, different chances of success, different approaches to preemption. Mark will compare and contrast these programs. In the meantime, as it would be obvious to you, if you are representing a client, there are many possible remedies for their health care and to keep money in their pockets. The articles and the seminars will talk about them, but obviously they include but are not limited to workers' compensation, and Ken Platt and myself will talk to you about that. Private health insurance, Medicare and Medicaid, short-term disability and long-term disability, unemployment compensation, the list goes on. And there are employment considerations. David Sesserman of our group will talk to you about those with respect to ADA, FMLA, and OSHA coming up, and whatever else is on your mind. I suppose if you have questions, you can put them in the chat room and our moderators can tell us what those questions are. And in some instances, as Mark will tell you, you might be able to go to state court and sue under whatever tort or contract or whatever theory you can think of. The point is, when someone comes to you with a particular fact pattern, be emboldened, be optimistic. There might be remedies there that you didn't think were present. And we think you need to know about them, and that's what we're trying to do today. As I said, there are some fact patterns. You can look at those at your leisure. Mark Saliman is our next speaker. He is an astute, ethical, and very thoughtful trial attorney. He knows construction litigation, personal injury, contract actions, the whole gamut. I've worked with him. I know he is a great attorney, and he's going to talk to you about those federal programs and state tort remedies. So Mark, I'll turn it over to you. Mark Saliman of Saliman Law.
Oh,
I can switch chairs.
No, I can sit here. I just worry about the background.
Yes.
Okay. Let's see if we can make this. All right. Well, thank you, Greg. Thank you. You know, working with Greg for a while here, I've learned that he's always a ray of sunshine and hope. And I've always had a reputation with whatever practice I've been in as a wet blanket or a Debbie Downer. So with that said, I think probably the biggest question on anyone's mind in a program about vaccination injury and vaccination injury claims is, what do I do with COVID-19 vaccine cases? And so I'll just take away the sitting on the edge of your seat for that. The answer is not much. Those are really bad, and there's very little that can be done for those people, at least currently. But we'll talk about that. I look at these vaccine injuries with essentially a flow chart or a triage, figuring out what sort of claim you have. And that really is dependent on asking the first question. And that first question is, what's the vaccine? So if you have a potential client give you a call and they say they've been injured, that they got a vaccine, you need to figure out what vaccine they received. Now, many of the most common vaccines that people get, school-age children, young people, even adults, are protected by a federal law called the Vaccine Act. And the Vaccine Act has a table which tells you the vaccines covered by the Act. And that table is at 42 CFR section 100.3. Here's a copy. We can make it available to anybody. And it lists about 15 common vaccines: tetanus vaccines, pertussis, MMR vaccines, polio, Hep B, Hep A, rotavirus, varicella, and seasonal influenza vaccine. So if a client approaches you and reports an injury and has been vaccinated by any of those vaccines, you are probably looking at a claim under the VICP, the Vaccine Injury Compensation Program, which is a statutory program. It's codified at 42 USC section 300 AA 1 at SEC. And that's a program that's a judicial program administered through the US Court of Claims in DC. And we'll talk about that a little bit. If a client comes to you and they've been suffered a vaccination injury and it's not one of those vaccines, you need to determine whether the vaccine is a public health emergency countermeasure. So that program is run under a federal statute called the PrEP Act. The PrEP Act has been around for now about 15 years. It's designed to give health and human services some broad authority to deal with various public health crises, whether man-made or microbial. And what the PrEP Act does is it gives the director of HHS some pretty powerful authority to declare public health emergencies. And then within that emergency to declare the sort of countermeasures that might be applicable to the emergency. At this point, there's about 10 public health emergencies that have been declared under the PrEP Act and are still current. Zika, Ebola, botulism toxin, and most recently in the spring of last year, the COVID-19 public health emergency. And I would advise anyone who is talking to a potential client about a COVID vaccine problem or any COVID treatment, somebody who say was hospitalized and suffered an injury during their hospitalization, suffered an injury from an antiviral drug given to them under COVID, suffered an injury from a ventilator or a respirator. Anyone with any injury like that, you need to read the PrEP Act declaration and its 7 or maybe it's now 8 amendments to figure out, is the countermeasure covered? Is the person who provided it covered? Is your injured client covered? Now with vaccines, I can sort of broadly state that it's hard to envision a program that gives more broad immunity to more people than the COVID-19 declaration. Really, almost anyone from the manufacturers of the drug, the scientists approving the drug, the transporters of the drugs, the providers of the drug, even the parking lot attendant who's ushering traffic into a facility to get shots, to get COVID shots. Almost every one of those people involved in any way in the administration of the COVID vaccine is going to be immunized, which is a good word. They're going to have immunity under the PrEP Act. And that is going to leave them with really only one remedy, and that's a remedy under the countermeasure injury compensation program. Then you've got a third group. Third group are people who might come to you who have suffered a vaccine injury from a vaccine that's not a countermeasure, and it's not on the list of Vaccine Act vaccinations. Some examples, the shingles vaccine. That's fairly common for adults, and it is not covered under the Vaccine Act. There's been some litigation, and we probably won't get time to get into that, but some interesting, it provides an interesting problem, which is the shingles vaccine is a varicella vaccine. Varicella is listed in the Vaccine Act. So an unwary attorney might think that a shingles vaccine is covered under the Vaccine Act, but you have to go through more detail to understand this to realize it's not. It's for a different purpose. It's not taxed under the Act, and so therefore it's outside the Act, and you don't get the federal remedy. Other vaccines could be, common travel vaccines, yellow fever vaccine, something like that. Well, maybe not common, but if you're traveling to certain parts of the world.
How about dengue fever?
Or dengue fever, thanks.
And those are examples 8 and 9. The Shingrix serum is
Yeah.
8 and 9 is dengue. Go ahead.
Okay, thanks, Greg. So if you fall into one of, if your vaccine is not in sort of category 1 or category 2, you don't have a federal program and you're free to pursue whatever state law tort remedy claim or product liability claim or strict liability claim that you can come up with. And we'll talk very briefly about that. Those are really, that's a subject of a different presentation. So let's go now to the first one. Or again, we'll just we'll go to the second one first, which is COVID, because it's probably what people are most interested in. So in a COVID case or other PrEP Act declaration countermeasure case, the CICP remedy is completely exclusive. There is no other state law remedy. There is nothing else you can do. There is complete immunity outside of that. The threshold for bringing a claim is that you have to suffer a serious physical injury. Now, the regulations under the CICP define that as something that requires hospitalization, though you don't need to be hospitalized. It's just something that should be hospitalized. There's no time limit for how long you have to be injured, no amount of medical bills you need to incur, just that you have a serious physical injury. You have a statute of limitations on that claim of 1 year from the day that you got the countermeasure. It's a completely administrative remedy. And so you file a petition directly with Health and Human Services. If you go to the Health and Human Services webpage, they have the forms on how you file and what you need to provide. It's a no-fault system, but you do need to prove causation. And the causation standard is high. The causation requires reliable, valid medical and scientific evidence of the injury being caused by the vaccine. And proximity in time is not determinative. So simply because your client got a vaccination and then came down with an injury 2 or 3 or 4 days later, that's not going to get you there. You need more scientific proof. There's a concept under the CICP and the VICP about something called table injuries. So commonly encountered injuries for which causation is presumed, a rebuttable presumption, but presumed to exist. Now, specifically for COVID, there are no table injuries. So any injury you have is going to be off table and you're going to need to prove causation. There's really only one other example in the CICP world of a table injury, and that's a pandemic influenza vaccine. So there's a declaration of essentially avian flu, H1N1 flu, has a PrEP Act declaration. Vaccinations are a countermeasure. And I think it's very illustrative in the COVID world, and certainly very useful in the pandemic influenza world, to see that there is a table. And I think the table, while it's not while it doesn't prove your case of causation, it could certainly be useful to talk about the kinds of table injuries that existed for injections, arm injections, and that would be anaphylaxis, deltoid bursitis, and syncope, fainting. That those are all recognized injuries for influenza, pandemic influenza vaccines. And so they may be available as well for a COVID vaccine. But again, there's nothing presumptive with COVID. The damages, so if you submit your package with your medical. So you're going to have to submit all of your clients' medical information, including a year of complete medical history. Then the question is, if HHS in a really closed, no hearing paperwork review, if an administrator decides you're eligible, what can you recover? The recovery is pretty limited. You can recover under CICP past and future unreimbursed medical expenses, past and future unreimbursed lost income, which is capped at a percentage of your yearly income, either 66% or 75%, depending on dependents, with a cap of $50,000 a year, and a death benefit if the vaccination kills you of up to $250,000. What's important about this is they are unreimbursed expenses. And so the CICP program, just like the VICP program, is a secondary payer. Any first party obligee to pay a bill, whether it's health insurance, whether it's workers' comp, whether it's another program, they have to pay first. They don't have a lien against any recovery, but you're not allowed as the claimant to recover any of that money paid by a first party. So it's a pretty low quality program. There's no appellate review. There's a procedure for asking HHS to reconsider its decision if it's an adverse decision, but no appellate review, nothing else. You're just limited to that exclusive remedy. The VICP is a better remedy. That's also a no-fault remedy. It also requires proof of causation. And it also has a table, but there, and I already showed you before, the table out CFR 42 CFR 100.3 lists a number of types of injuries that can be presumptively caused by specific vaccines. If you don't have one of those injuries, then you are going to have to prove causation. That claim is it's a judicial remedy in the Court of Claims. So you need to file a petition. That needs to be filed within 3 years of the injury. And I'll just warn you, you need to be very careful with the 3-year statute, because a 3-year statute is longer than most state law statutes of limitation on the kinds of claims you might bring. And if it turns out that you're wrong, and you say bring a shingles claim under the VICP, and you bring it at 2.5 years and you get kicked out because it's not a VICP injury, you're not going to have the benefit of any tolling, and you're going to be too late to bring a state law claim. So the advice is that you should bring everything in the earliest possible deadline. The remedies for the claim are better. You can get past and future medical, and it's a broader scope of medical, including rehab. And you can also get past and future lost income, a death benefit. You can get non-economic loss up to $250,000. And a successful claim can get attorney's fees and costs, and even an unsuccessful claim brought in good faith can recover attorney's fees and costs. So it's a much more claimant-friendly proposition. The claims are handled, they're defended by the DOJ. They're handled initially by a special master, a panel of special masters in the US Court of Claims. They have strict timelines on when they must issue a decision. It's 240 days, though it can be expanded to 390 days. If they don't issue a decision by that time, you can opt out of the program and choose to go to state court. If they do issue a decision and either you don't like it or the DOJ doesn't like it, you can get review from a judge on the Court of Claims. They also have a strict timeline, 420 days to issue their decision. And again, If you don't like the decision as the claimant, you can opt out it. If they don't, well, I'm sorry, if they don't decide on time, you can opt out. And if they do decide and you're unhappy, well, you can continue the federal appeals process all the way up to seeking review in the Supreme Court, though I don't think that's happened. But you can also opt out, choose to not accept your judgment, and have 90 days after a judgment to opt out. And if you opt out, you can bring a state law claim. The limitation, you can't bring state law claims against a manufacturer for a design defect. So you would be left with, maybe medical malpractice claims or other type of claims, but not a defective product claim against a manufacturer for one of the vaccines covered by VICP. And then finally, and I'll just cover this for about a minute, state law remedies. So either if you opt out of your VICP program, or if you have a vaccine that's not covered by any of the federal programs, what's left for you and your client? Well, it would really be any other type of remedy you have from a defective product. So if you have a defective vaccine, either an unreasonably dangerous vaccine under strict liability or one that was negligently manufactured, you could have a claim there. If you have an administration claim, you go to the Walgreens pharmacy to get your shingles vaccine. They give you the vaccine. The guy tells you to get up and go wait in the other room. In 2 seconds, you stand up and immediately black out, fall, hit your head on the floor and suffer a brain injury. You might have a claim there because it might be unreasonable care by the vaccinator to have you stand up right away, particularly if you've told him ahead of time that you get faint when you get shots. So you would have any number of claims, and on all those, you'll just be limited to the damages available and the litigation limitations of a claim. A medical malpractice claim, you're going to need expert testimony. You're going to need a certificate of review. Defective product claim, you're going to deal with extremely expensive and difficult causation issues in a medical causation claim. Really, the general advice I think we would all have there is, if you have a claim like a shingles reaction, a reaction to the vaccine with a significant neurological injury, look for a multi-district litigation case already pending. With shingles, for example, there's one in the Eastern District of Pennsylvania. There's already more than 50 cases from around the country consolidated there in a multi-district claim that's going to deal with proving causation and proving fault on a group level and just leave you for your unique damages. So it's a difficult landscape. There's a lot to cover, and now we will move on to the next set of remedies.
But before we do, everybody, Mark and I have discovered this book. I referenced it before, Vaccination, Immunization Law by Brian D. Abramson, published by Bloomberg Law. We recommend that to you. It's got a lot of fine points. This guy is a nerd on vaccination injury law, but so now is Mark Saliman. He has shown you that he knows his stuff. He's a smart guy. No, he's a smart guy on vaccination. And I forgot to mention, he's only one of two that's on the U.S. Court of Federal Claims list of attorneys who have indicated they're willing and able to take vaccination injury cases in the state of Colorado. Now, David Sesserman may be applying, hasn't yet. Maybe I'll be applying, but Mark, my final comment is Mark and I are currently working on 2 cases together, neither of which are work comp cases. We're going to be filing petitions in the second fund that he described, because these are both what we call SERVA injuries, shoulder injuries involving non-COVID vaccinations, flu shots specifically. So thank you, Mark, very much. Now we're going to team teach. The gentleman and I next to me, his name is Kenneth Platt, Kenneth M. Platt and Associates. He is extremely knowledgeable in workers' compensation. Why? He used to be the director of the Division of Workers' Compensation and served faithfully for several years in that position. He also was a merits judge at the Office of Administrative Courts, trying or hearing, I should say, workers' compensation cases. He did that for several years. And he has, I think, decades, 30 years maybe, of private practice representing claimants in workers' compensation. He's going to wear the claimant hat in the discussion of workers' compensation, and I'll, to the extent I can, wear the defense hat as we talk about workers' compensation. Ken, tell us a little bit about the overall philosophy and structure of work comp, particularly as it relates to vaccination remedies.
Well, Greg, thank you. I'll keep this very short, kind of a high-level review, because we're short on time in today's presentation. First of all, many of you may be aware of this, but the benefits in workers' compensation are limited. There's no pain and suffering in workers' compensation. There is medical benefits, 100% coverage, temporary wage loss, and possible permanent wage loss, which is an ongoing and developing area, of course, in vaccination law. This is a no-fault system, they say. However, most claims we're finding in vaccination law areas especially are being denied. There's various reasons for that. Greg will go through some of that when he goes through some of the scenarios that we're bringing to you in the next few minutes. The two focuses, what I would have you focus on are two issues at the beginning of a case that may come to your office. The first is we have the causation issue. Many of the problems that have already been discussed by Mark are the same in workers' comp, establishing the connection for causation. However, additionally, we also have to consider the issue of nexus to employment. That's a very interesting area that's developing. It may come down to gray areas such as the ability of the claimant to prove to a judge that their perception of the necessity of having the vaccination was reasonable, and that the employment did in fact requirement, though it may not have been spelled out. Greg, why don't you take us through some of those scenarios and show what we mean.
Okay, so you probably have them by now. If not, I'll just briefly summarize a few of these scenarios with the reference to workers' compensation issues. Case number one, COVID vaccination that goes awry in Colorado Springs, a federal employee. Ken, are you an expert in federal workers' compensation?
No, and that's an important point, but most people may not be aware of it. They're not experienced in the area. There's a state workers' comp system. Every state is different. Colorado obviously has its system. That we do know about it. We've had thousands of cases that we've tried or sat in judgment on. The second area that we know absolutely next to nothing about, would you say, is, well, both of us, is the federal workers' comp system. It is completely different, and there's only a handful of lawyers that practice federal workers' comp claimant work. If one of you decides that that's something that comes across your desk and you wish a referral, let us know, and we'll be happy to refer you to some of the folks that do it.
Yeah, we'll find that person for you. In this particular fact scenario, the employer required this federal worker to have this vaccination. We're not going to comment on whether that's covered or not. We just want to make you aware there is federal workers' compensation. So let's turn to case two, which is a Colorado employee, not federal employee, if you will, has a COVID vaccination with an adverse serum reaction. It's a Johnson & Johnson serum that causes some clotting condition in this hospital worker. She was required by the employer to have vaccination. Generally speaking, what's the claimant's view? If the employer requires the vaccination, is that usually a slam dunk when it comes to workers' compensation eligibility?
I say with a qualified yes. It would be perceived and certainly probably adjudged as a requirement of employment. However, take that with a grain of salt because the establishment of the facts may be limited or difficult.
Okay. Does it matter if it was administered in the employer's on premises or off premises? Do those facts matter?
They do matter. They're relevant, but they're not definitive. Could be either scenario.
In this case, the woman actually dies. Death claim, what kind of remedies available for the estate?
There's death benefits in up to, I believe it's $7,000 now, which could be paid towards funeral expenses. If it really depends on whether there's dependents or not. If there are dependents and it's a wife, she would receive the benefits that would have otherwise gone to the injured worker until she either remarries or passes away. So that would be a lifetime benefit. The other scenario would be when there's children involved or other dependents. Let's say there's 3 children which were dependent at the time of the injury and death. The same benefits would be given to them, split evenly between the 3. That would continue until each child is either emancipated or reaches the age of 21.
What's the statute of limitation for filing a work comp case in the state of Colorado?
It's 2 years in general. There are situations where if you have a sufficient reason that would be allowed to be filed between the 2 and 3 year, in other words, 3 years would be the limit. But generally, we strongly advise that you do so within 2 years if possible.
Okay. What if the employer only strongly encourages a vaccination or gives them a pizza if they go get it, or cigars, or gives them time off to go and have the vaccination? Is that, from the claimant's perspective, going to bring it under the course and scope of employment coverage?
It certainly would be the argument that most claimants' attorneys would make. It comes down as many things as to the actual facts. For example, if the employer pays for the time off, pays for the transportation, and any other costs that go along with it, it may be a reasonable presumption that it was in fact approved of and required by the employer as a term of employment. On the other hand, a pizza, well, I don't know, that might just be he's a nice guy, gives him something to eat. But on the other hand, it has to be a reasonable compensation. In other words, what would indicate to the court that this individual is acting at the direction of the employer, whether that was direct or indirectly stated?
I can tell you from the defense perspective, we're going to deny those cases. We're going to say that's voluntary activity, blah, blah, blah. But it's not voluntary recreational activity. It's not preparation for a fitness test. There's no body of law, particularly on that particular issue that I'm aware of. But I would be troubled as a defense attorney if the claimant would testify and others in the organization would back them up, that they felt pressured to do this. Everybody else was doing it, and they felt they would not persevere and survive in the job unless they cooperated.
For example,
what would you say about that?
Well, absolutely. An example might be that the injured worker is aware that in the past, other people have made claims, and when they refuse to, for example, get the vaccination that's being discussed, suddenly they are transferred to a less desirable position in the company. Maybe their hours are reduced, pay raises may not occur. Things like that would be a reasonable, that may rise to a reasonable belief on the part of the injured worker that this is in fact being enforced as a requirement of employment.
I'm now looking at case number 6. It's a seasonal flu shot, and they have a serum reaction. They were strongly encouraged. If they were to get benefits, if they were to be successful, are there offsets available to the insurance company for receipt of other benefits, such as short-term disability, long-term disability, Social Security, et cetera, et cetera?
Short-term disability and long-term disability is in fact offsettable. So workers' compensation benefits would be reduced by those amounts. Often it's a dollar for dollar, depending on the contract for the short-term or long-term disability. Social Security is an interesting area that's absolute. There are 15 states in the United States who work as Colorado does, and that they allow the insurance carrier to have an offset of 50% of what benefits are gleaned from the Social Security Administration as an offset to reduce the liability of the employer or insurance carrier. The other states do it the other way around, and it's Social Security that benefits. But for this discussion on Colorado, just be aware, I think that Social Security does result in some offset.
And this particular case is a school teacher. She may be entitled to para. It's going to depend on the percentage of contribution by the employer about what's the percentage of offset. But speaking of offsets, if you look at case number 7, it does raise a very interesting issue. Say somebody does qualify under the Vaccination Injury Compensation Program, the VICP, and they get a bunch of money from the federal government. Can the insurance carrier in the work comp case take an offset, or have better stated, have a subrogation interest in getting recovery from the funds that they're getting from the federal government?
My understanding is at this point in time, with law that's been established up to this point in time, they may not. Oftentimes there are offsets, but that's not one of them because it's simply not listed as an allowable offset within the workers' compensation.
And let me drill down on that. I've done some R&D on this issue, and it's my opinion, and it's contrary to the defense perspective for the insurance companies, that they do not get an offset or have a subrogation interest in federal funds, because there's no statutory, regulatory, or case law authority that allows them to get that. And Mark and I looked at it just yesterday, and I think we came to the same conclusion, right, Mark?
Well, that's right. And Greg, I'd even point out something different, which is, as we discussed earlier, talking about the VICP program, it only pays compensation for otherwise unreimbursed or reimbursable damages. And so if a claimant has $500,000 in medical expenses that have been paid by workers' comp, and they have been paid a number of lost employment benefit through workers' comp on a disability claim, and they bring a VICP claim, what they're going to be able to recover is not that $500,000. They may recover other out-of-pocket medical expenses. They can recover other uncompensated employment benefits. They can recover non-economic damages. So there wouldn't be a subrogation right there because they weren't paid that. At least that's the operating theory.
Well, this is a new landscape in terms of vaccinations for COVID, and also compensability of those who contract COVID in the workplace. And we stand ready to consult on any such cases you would have on any side of the table, claimant or defense, because we've been looking at it and actually are trying some of those cases. I want to give fair due to our next speaker. So Ken, I want to thank you for your contribution on the workers' compensation issues. This is just a survey. So much more you'll hear at the seminar coming up and in the articles that are coming out. Our next speaker, David, you want to come around?
Sure.
Is David Sesserman of Sesserman Law, LLC. He is an accomplished and experienced trial attorney as well. He has an expertise in many things, but one of them is employment law. He is a frequent CLE speaker. I know that for a fact because every time I see an ad for a CLE, he seems to be speaking on it. And we're so pleased to have him here today. And we'll be pleased to have him on August 24th to speak at that seminar. He's going to talk about the employment law considerations regarding vaccinations. David, take it away.
Thank you, appreciate it. I just want to talk about kind of from a highlight some of the major employment law concerns, as well as the laws. It is, the world of employment law and COVID is, to say the least, very fluid. It changes every day. The only thing I can tell you for sure right now is that what is in place today may not be in place tomorrow. By way of example, as of a couple of weeks ago, in a classroom setting in the state of Colorado, students, teachers were all required to wear face masks. That went away. That could come back. We don't know. There is the Delta variant that is out there right now. That could be followed by an Epsilon variant that hasn't even come out yet. And that will change things. Right now, we are in a situation where the workplace is opening up, where life is beginning to return in general, much more normal than it was before. We're actually in a conference room today. 2 months ago, that probably wouldn't have been the case. A year ago, it absolutely would not have been the case. So a couple of questions that come up in the workplace. Number one, can an employer require an employee to get vaccinated? The general answer is yes. However, that yes answer is qualified very particularly by ADA concerns as well as Title VII concerns. So if somebody has a religious belief that he or she or they should not be vaccinated, end of story. An employer cannot force it. An employer can say, well, we're a healthcare institution, then you can't come to work here. And that raises a number of accommodation issues, which haven't changed. The ADA, the FMLA, Title VII, all require some reasonable level of accommodation. And that's an iterative discussion that must take place between employer and employee. And that has not changed. So back to it. Can a employer require a vaccination? In general, the answer is yes. Does an employer want to require a vaccination? We just heard Ken and Greg talk about workers' compensation. The question that I think is asked is, why does an employer want to require a vaccination? And if an employer does require it, then is a determined condition of employment. Hence is any injury that occurs there, workers' compensation. So what's happened in the world of employment law? You have the CDC that everybody is familiar with has been issuing guidance after guidance. Most of the other governmental entities have played off of that. The EEOC has issued several guidance pieces and publications talking about what about COVID in the workplace. Recently, and we're talking about 6 weeks ago, OSHA finally came out and issued guidelines. The OSHA guidelines follow the EEOC, which follows the CDC, which, as I mentioned earlier, changes depending on various factors and what is going on politically, economically in the world. So under OSHA, employers have an obligation to provide a safe workplace. That means what happens if an employee says, I don't want to return to work. I don't feel safe. Can an employer, without violating OSHA, require that employees return to work? Current answer, yes. However, what hasn't been decided yet, and where so far OSHA has punted, is what happens if there is a temporary situation where an employee refuses to perform that employee's job because that employee doesn't feel safe in the workplace because of COVID. We're trial lawyers. So in a trial law setting, what happens if you're sitting around a conference table and the court reporter starts hacking and coughing and is showing even symptoms of COVID? If you're an attorney, can you walk out and say, I don't feel safe here? That answer is not clear. That answer is, we don't know what's going to happen there. My own personal prediction, I think you will see litigation under OSHA down the road. I think Title VII, I think the EEOC guidance is pretty clear. EEOC is leaning towards, yes, look, employers can still require reasonably certain precautions in the workplace. An employer can require masks to be worn without violating EEOC, even though as a practical sense, nobody does right now. A year ago, workplaces required temperatures to be taken on the way in. You don't see that so much anymore as the world is opening back up. But again, does the Delta variant or a subsequent variant change things? It could. So there's a lot of discretion that is there. So, what, I guess from just an overall perspective, what is the impact of the Family Medical Leave Act, the Americans with Disabilities Act, Title VII, the answer is they haven't really changed. Now, if somebody is injured because of FMLA or is out sick, are they entitled to FMLA leave? The answer is yes. Is somebody disabled because they're sick under the ADA? Maybe. It kind of depends. Outside of the scope of this discussion, you know, a lot of states have taken certain steps. I want to get this right, but, you know, Colorado has enacted the ever-changing Healthy Families and Workplace Act, which requires employers in the state of Colorado to provide essentially sick time that accrues at a minimum rate of 1 hour for every 30 hours of service, so that somebody who is impacted by coronavirus, and it's been extended to a number of other things, including mental health, spousal abuse, but it now requires that employers provide employees with some level, at least a minimum level of sick time to accommodate situations that come about, again, from COVID and from other situations. That's really kind of outside of the scope of this. So that's a real high level of what's going on in the world of employment law. People are returning to work. Employers are a lot of employers are requiring a return to work. Many are going to the hybrid situation. And, you know, all of these laws still apply. I should add, I talked about reasonable accommodations. One of the big changes in employment law is this whole concept of what is a reasonable accommodation with respect to remote working. A year and a half ago, a lot of employers said, I'm sorry, we can't accommodate that request to work from home. I don't care if it's because you have a young baby, you have a sick child, you don't feel well, whatever. Your job cannot be performed remotely. That's all changed. Now, all of a sudden, you know what? Working from home or working from home part-time is generally accepted as a reasonable accommodation. And so it is one that needs to be looked at, for instance, with that employee that I mentioned before, where that individual says, I don't feel safe in the workplace. The next discussion needs to be, can we reasonably accommodate your situation? So that's a real quick overview. Greg, I'm gonna turn back to you in case there's any questions.
Oh, no, you're not going anywhere.
Oh, yeah.
I have questions. And Miranda and Crystal, we're going to ask you in a minute if there are any questions in the chat room, but I have one now for David right
Sure.
now. An employee says, I have to go back into that cesspool over there at work. I want to know who's had vaccinations and who hasn't. And so can you comment on confidentiality considerations for the employee who wants that information and for the employer who wants that information as well?
It's not 100% crystal clear, but here's the answer. First of all, the employee who says, I want to know specifically who's gotten vaccinations, that person is not going to be able to find out.
Why is that? Why is that?
Because it is considered personal information. It is probably more protected, quite frankly, in a private employer by the ADA than it is by HIPAA. There's been a lot of, again, a year ago, the common sense understanding of HIPAA was HIPAA applies to all health information in an employee's files. And now that people have read HIPAA more carefully, there's a general understanding, yeah, that's true if your employee is a healthcare institution. But if you're not a healthcare institution, HIPAA may not apply to that, but the ADA certainly does. And as well as privacy, a number of privacy rules and statutes or just general understandings of what is protected information. So no, employers cannot just say, hey, let me go down the list. I'll tell you who was vaccinated, who's not. Can an employer require anybody who's not vaccinated to wear a face mask? Absolutely. What happens when that's enforced? Different questions. Question.
Okay, right. HIPAA doesn't apply to work comp generally for those who have a right to know the payers for the medical bills and the records and so on. Is that
Right.
generally true? How about FMLA? Somebody says, hey, the employer didn't designate it. And I didn't designate it yet. Can the employer designate against the employee's will just to get that clock ticking? What's your view on that?
Yes, if the employer has the information. Again, in order to take FMLA, there has to be an explanation from the employee and say, here, I need time off because. There can't necessarily be a lot of follow-up question about the because. That depends on situations. But yes, then it's up to the employer to say, I am designating this as FMLA, which, most employers, under the strict reading of FMLA, you're talking about unpaid leave. So employers as a whole don't really generally resist placing an employee on FMLA. Now, can they require some sort of a doctor's note to come back? Depending on the situation, the answer is yes, in most cases. And when it's FMLA, the answer is in the vast majority of cases, yes. The other thing, and you mentioned this earlier, Greg, to think about is disability. Because if somebody really does have an injury that they've sustained, they certainly ought to be thinking about short-term and, if necessary, long-term disability benefits that they may have regardless of everything else. But that may provide some of the best coverage out there because, what is not protected is if an employee can no longer perform their job because of an injury, that person can't perform a job. And it's no different than for any other reason. And so disability still needs to be in play.
David, thank you for those insights.
Sure.
Miranda or Crystal, any questions in the chat room you want to tell us about?
So let me take myself off of mute. I
Sure.
don't know if you all can see the message from Susan about the Healthy Families in the Workplace Act, as it now requires larger employers to provide paid sick time for employees to get vaccinated. It will apply to all employers in January of 2022.
Right.
How does that, coupled with posters where the employer says they strongly encourage vaccination, factor into the course of employment analysis? That's a great question, Susan.
Great question, Susan. Appreciate that input. Any comment, David?
It's a good question. It's a little complex. I'm not sure I quite get all of it. Yes, Susan is 100% correct. Right now, just 2021, it doesn't apply to every employer. It's employers with under 16. Yeah, under 16, over 16 and over. It goes to every employer next year. There are workplace poster requirements that fall under the act. I should also add, there is an anti-retaliation sister act that goes along with this, and so employers cannot retaliate. What is unclear is this is a benefit that accrues, and some of it can be carried forward to subsequent years, but there's a cap on how much can be used. Since this came out, the Colorado Supreme Court ruled in a decision that essentially any benefit, that any wage that accrues, and that includes all forms of PTO, again, it's subsequent to the enactment of this, is something that must be paid out upon termination. So that's an issue where I can see some future litigation, even though the intent was, at least initially, was the Colorado Act would not be something that had to be paid out upon termination. That's a great way of not answering the question.
Can I clarify?
Please, Susan.
That was great answer. And I'm also curious, Greg, the workers' comp implication to an employer who doesn't mandate vaccinations, just strongly encourages them, and of course has to pay for the time off to get them and recover for them how might that factor into a workers' comp
I-
claim?
Did I pay you to ask that question? Susan?
And before you start, I should add, part of the Colorado Act, the Healthy Families and Workplace Act is employers must give time off, paid time off for something like a vaccination. So go ahead.
My short answer is, I start with the Colorado Work Comp Act. That employer, that's an exclusive remedy for the injured worker. So unsafe employers only have to pay workers' compensation, but actually it's their insurers that usually pay it unless they're self-insured. The insured carriers are going to be actively requesting that their insured employers make masks mandatory, do social distancing, have vaccinations, et cetera, to reduce their risks and their costs of defending these cases. I don't know if that completely answered it, but those are the work comp implications. The employer can be tagged for having an unsafe workplace in the form of benefits to injured workers. And we're submitting to you, Ken Platt and I, that if the vaccination is required, those are going to be cakewalks in most cases. And if it's strongly encouraged, we're going to, as a defense attorney, going to have a hard time defending against those if there's pressure or coercion that they feel to have the vaccination. Would you agree, Ken?
Absolutely. Which is factual issue.
We could talk so much more, but we're past our hard stop.
And to the extent. as you're
Okay, and
saying,
Mark will talk. Go
Yeah,
ahead.
just to the extent that you're talking
Yeah.
just the COVID vaccine. And you do now find a way in this broad swath of cases to force it into the comp system under this state dictate, essentially.
Yeah.
You have to recognize then that any injuries that result from the vaccination are going to be in a CICP program, which does not provide a recovery for a reimbursed claim. So anyone who comes into your office outside of the comp world, outside of the employment world, and wants to know, hey, can I sue the manufacturer? Can I sue Johnson & Johnson? Or can I sue, the Walgreens that gave me the shot because I have a bad arm or I have a bad reaction? Well, their damages are going to be very limited, making those cases even less appealing for a lawyer to assist with, because there won't be any pot to recover.
There you go. Great point. As we've demonstrated to you, there's a lot of interrelationships between these bodies of law. I can immodestly say, well, why be modest with them? We've assembled as a team, I'll call it the VA team of brainiacs, who are there to help you out with your vaccination injury cases. We stand ready to help. Thank you very much for this opportunity to address you today, and we hope you enjoyed this presentation and got some glimmers of insights about how this very complicated area of law works. Thank you, take care, and thank you to my speakers, Mark Saliman, Ken Platt, and David Sesserman.
Thank you, sir.
Thank you.